or Harvard, the Supreme Court, and the fame of defending O.J. Simpson enough to guarantee an easy win on live television tonight. A young Yale-trained attorney, forged in the everyday courtrooms of Texas, proved the answer is no. Alan Dershowitz, 85, Harvard law professor emeritus, a legal icon who has influenced thousands of attorneys and represented clients from Jeffrey Epstein to O.J. Simpson, stepped onto the set with a stack of papers in hand. He publicly declared he had the evidence to expose his opponent's lack of legal understanding, confident he'd cruise to victory over a Congresswoman just 2 years into her first term in the House. Opposite him was Jasmine Crockett. Her chestnut suit and gold necklace stood in sharp contrast to his formal Navy ensemble. At 43, a former public defender and civil rights attorney, Crockett didn't rise through elite seminar rooms. She rose from the front lines of the courtroom, where she defended ordinary voters long before representing them in Congress. The on-air light glowed, their eyes locked. Neither looked away. Dershowitz wasn't there to discuss. He was there to dominate. "I've been teaching constitutional law since before the Congresswoman was born," he said in a steady Boston cadence, stacking the wall of prestige higher. He was deliberately diminishing his opponent's expertise. Crockett offered only a slight smile, not polite, the smile of someone prepared for exactly that tactic, the other side's complacency. The debate over the Voting Rights Protection Act began. One side wagered on academic sheen and a long record of case law. The other leaned on the Constitution's text, hard data, and lived experience. As the cameras shifted angles, viewers could feel the fault line forming. Will prestige or argument lead the night? If you want more stories like this, where knowledge and composure go head-to-head with raw power, hit subscribe and join our community at the Jasmine Crockett File. We bring you political moments that not only shock, but inspire. You'll want to catch every second of how Congresswoman Crockett flips the script on one of America's most celebrated attorneys. "Good evening," Crockett sighed evenly, her voice carrying a trace of her Texas roots. "Unlike some, I'm not here to lecture Americans from an ivory tower. I'm here to talk about legislation that impacts real voters. People I've represented both in court and now in Congress." Rebecca Mitchell nodded, sensing the growing tension. "Let's begin with the basics. Professor Dershowitz, you've called this bill an unconstitutional overreach. Congresswoman Crockett, you're one of its co-sponsors. What's at stake here?" Before Crockett could respond, Dershowitz leaned forward. "What's at stake is nothing less than the constitutional balance of power," he asserted. "The Congresswoman and her colleagues want federal control over what the Constitution clearly reserves for the states. This isn't just poor policy, it's unconstitutional. I'm surprised anyone with a law degree would support it." The camera caught Crockett's faint smile, not amusement, but recognition. She had faced countless prosecutors and opposing counsel who used similar tactics, dismissive, condescending, and eager to undermine her expertise. Behind the scenes, her team had prepared thoroughly for this very approach, analyzing Dershowitz's debate style, his tendency to interrupt, assert intellectual superiority, and sidestep opposing arguments instead of engaging directly. What Dershowitz didn't realize was that Crockett had spent her weekend reviewing his past writings, not just recent comments on voting rights, but also essays from the 1970s and 1980s that directly contradicted his current position. She had even spoken to 3 of his former Harvard students who offered valuable insights into his argumentative habits and weaknesses. Meanwhile, in the control room, CNN producers watched closely. The segment had been framed as a substantive policy discussion, but the personal tension between the 2 lawyers was creating far more compelling television. The network's social media team began uploading clips of Dershowitz's opening remarks, anticipating that the exchange was about to go viral. The stakes extended beyond the Voting Rights Protection Act for Dershowitz. It was about preserving his legacy as one of America's most prominent legal minds in his later years. For Crockett, it was about proving that a new generation of lawyers, diverse, grounded in community experience, and fearless in the face of establishment power, deserved to be heard as equals in shaping the nation's legal future. Rebecca turned to Crockett. Congresswoman, your response to the professor's constitutional concerns? Crockett straightened her papers, her expression shifting from polite to focused. I'd be glad to address those constitutional points. Rebecca. But first, viewers should understand something essential about this discussion. What people need to realize, Crockett continued, her voice firm and clear, is that interpreting the Constitution isn't reserved for Ivy League professors. It belongs to every American, especially those most affected by its interpretation. Dershowitz raised an eyebrow, opening his mouth to interrupt. But Crockett kept going. The professor implies I misunderstand constitutional law. Let's address that. Article 1, Section 4 clearly grants Congress authority over federal elections. The 14th and 15th Amendments further empower Congress to safeguard voting rights. This isn't advanced theory. It's written law. Dershowitz shook his head, visibly irritated. Congresswoman, I'm fully aware of those provisions, but the Supreme Court has repeatedly affirmed state authority in election administration, notably in Shelby County v. Holder. I'm familiar with Shelby County, Crockett replied, having litigated voting rights cases directly impacted by it. The question isn't whether states have authority, it's whether that authority can be used to silence voters. The professor's face tightened. That's precisely the kind of emotional argument that clouds this debate. The Constitution guarantees equal protection, not voting convenience. When voting restrictions disproportionately affect certain communities, Crockett countered. That's not about convenience, it's about constitutionality, Rebecca interjected. Let's focus on specific sections of the bill. Professor, you've criticized the requirement for minimum early voting days. Why? Dershowitz leaned forward. This is where Congress oversteps. States differ in population and resources. A uniform federal rule ignores these realities and violates federalism. I have statements from election officials in 17 states warning these mandates would cause logistical chaos. The Congresswoman is pushing ideology over practicality. Crockett waited patiently, then responded, Interesting you mention election administrators. I have statements from 23 states, including Republicans, supporting these standards as both achievable and essential. She turned directly to Dershowitz. Let's talk consistency. Professor, in your 1982 book, Rights of the People, you wrote that federal voting standards may be necessary when states show ongoing discrimination or failure. You specifically endorsed national early voting standards. Has the Constitution changed, or just your stance? The camera caught Dershowitz's brief surprise. He hadn't expected her to quote his past work, shuffling papers. He replied, Academic thought evolves with evidence. The voting landscape has changed since the 1980s. My earlier position reflected concerns about specific states at that time. So, constitutional principles shift with political climates, Crockett asked. Interesting for someone claiming to be an originalist. The tension rose as Rebecca pivoted. Let's discuss voter ID laws. Critics say your bill weakens election integrity. Those critics ignore evidence, Crockett replied. Multiple studies, including from the Brennan Center, show voter impersonation fraud is nearly non-existent. What's real is that about 25 million Americans lack the required IDs. Dershowitz scoffed. The Brennan Center isn't impartial, and suggesting millions can't get IDs insults voters' intelligence. Crockett's tone hardened slightly. Professor, Have you represented anyone who lost their vote because they couldn't afford ID documents? I have met elderly citizens without birth certificates. I have spoken to low-wage workers unable to visit ID offices open only during work hours. I have calling these real barriers insults shows exactly the ivory tower problem I mentioned earlier. Sensing he was losing ground, Dershowitz shifted tactics. Your anecdotes don't override state authority to protect election integrity. The Supreme Court has upheld reasonable ID laws. Then, let's talk about that. Crockett countered in Crawford v. Marion County, which upheld Indiana's voter ID law. The court noted that evidence of actual voter burden was limited. When strong evidence shows disenfranchisement, the constitutional test changes. She lifted another document. And in your 2005 Harvard Law Review article, you criticized judges who hide policy motives behind selective constitutional readings. You cited voter ID laws as examples of states using fraud claims for partisan gain. You're taking that out of context, he replied. M.I. Crockett raised an eyebrow. Would you like me to read the full paragraph? Rebecca quickly intervened. We need to take a short break. When we return, we'll continue our discussion on voting rights and hear from viewers. As cameras paused, Dershowitz leaned toward his aide, whispering urgently and pointing at his notes. Something had clearly gone wrong. His aide frantically searched through papers across the table. Crockett calmly sipped her water. A producer approached and asked if she needed anything. I'm fine, she said evenly. But you might want to check on the professor. We haven't even reached the real contradictions yet. When the broadcast resumed, the energy had shifted. Dershowitz looked composed, but firm during the break. I reviewed my own writings, not the Congresswoman's selective quotes. My position has always been that election laws must balance access and integrity. That's all states are trying to do. He faced Crockett directly. But since we're discussing credentials, let's be clear. I've argued over 50 Supreme Court cases. I've taught constitutional law to thousands of the nation's top attorneys with all due respect. Your brief tenure as a state legislator and first-term Congresswoman hardly qualifies you to lecture me on constitutional interpretation. The condescension in his tone was unmistakable and exactly what viewers noticed. Crockett had been waiting for this moment. Professor, she began, her tone calm but precise, the same one she used in court when an opposing lawyer made a critical mistake. I think it's time we address the elephant in the room. The issue, Crockett continued, voice steady as steel, is that you're relying on your credentials instead of engaging with the core of my argument. That might work in a classroom where students worry about grades, but this isn't Harvard law, and I'm not your student. Dershowitz's expression tightened. I'm addressing substance, he replied. You're the one bringing up old quotes. I'm pointing out how your views have shifted over time, Crockett countered. Let's focus on today's discussion. You claimed states should have brought authority over election procedures, yet in December 2020, you argued that legislators weren't even bound by their own constitutions when appointing presidential electors. That stance would have canceled millions of votes. She held up another paper. You wrote, and I quote, "The Constitution gives this power to state legislators, not to states generally. How do you reconcile that with your current concern for federalism?" Dershowitz shifted uneasily. That was a narrow legal argument about the Electors Clause, not general election regulation. Is it, Crockett interjected, because both deal with the same constitutional principle, balancing federalism with protecting the right to vote, yet your interpretation seemed to change depending on which political side benefits? The audience murmured as Dershowitz flushed. That's absurd. My positions are based on constitutional analysis, not politics. Crockett nodded slightly. Then let's review that analysis. You often cite Shelby County v. Holder to argue against federal oversight of state voting laws, but in that very ruling, Chief Justice Roberts reaffirmed Congress's authority to address voting discrimination authority this bill uses. She leaned forward. The difference, Professor, is that I've represented real voters impacted by Shelby County. I've seen polling places shut down in minority areas, voter roll purges that disproportionately target eligible minority voters, and ID laws crafted with precision to exclude certain communities. Dershowitz tried to interrupt, but Crockett raised a hand. Please, I listened respectfully to you. He went silent, realizing the shift in tone. You mentioned your Supreme Court experience, she continued. I respect that, but I've worked in state courts where voting rights directly affect people's lives. I've helped seniors reclaim their right to vote after bureaucratic hurdles. Constitutional theory meets real life in those cases, not academic debate. Lifting the bill text, she added. This legislation doesn't federalize all elections, as you claim. It simply sets minimum standards to prevent the worst forms of voter suppression. States still retain broad flexibility in how they apply it. Mitchell sensed the turning point and turned to Dershowitz. Professor, your response. Dershowitz composed himself. The Congresswoman's experiences are valid, but they don't override the Constitution. It gives states, not Congress, primary authority over elections. This bill exceeds that by micromanaging procedures. Section 306 alone includes 42 detailed mandates on early voting hours and locations. That's not a standard, it's a takeover. Crockett smiled slightly. I'm glad you brought up Section 306, Professor. It's modeled on a proposal you supported in congressional testimony back in 1991. You described similar measures as appropriately tailored federal actions that respect state authority while ensuring access to the ballot. The room went silent as Crockett displayed the transcript. This is from your House Judiciary Committee testimony, March 14, 1991. Would you like me to read it? Dershowitz blinked rapidly, caught off guard. I'd need to see the full context. Of course, Crockett replied, sliding the document toward him. Take your time. As he read, the camera captured his expression shifting from confidence to confusion to quiet dismay. The text confirmed exactly what she'd said. Crockett turned toward the camera. This highlights my main concern. Too often, voting rights are discussed as legal theories instead of real protections that affect real people. The same experts who once supported federal voting safeguards now oppose them, not because the Constitution changed, but because political interests did. Dershowitz, trying to recover, sighed. Even if I once supported similar provisions, and I'd need to confirm that the constitutional framework has evolved through later Supreme Court rulings. Which one specifically? Crockett asked evenly. Because Shelby County still upheld Congress's power to address voting discrimination, requiring only updated criteria for oversight. That's precisely what this bill does, based on current evidence. She turned back to Mitchell. Rebecca. The real question isn't abstract constitutionality. It's whether every American deserves equal access to the ballot, regardless of zip code, schedule, or ability. The Constitution's history and text clearly give Congress the duty to act when that access is under threat. Dershowitz, now visibly unsettled, shuffled his papers as the audience waited in silence. Crockett was accused of appealing to emotion rather than relying on constitutional logic. She raised an eyebrow. Am I? Then let's get specific about the legal reasoning. Article 1, Section 4 clearly states that the times, places, and manner of holding elections for senators and representatives shall be determined by each state's legislature, but that Congress may at any time make or alter such regulations. The text directly grants Congress ultimate authority. Furthermore, she explained, the 14th Amendment's Equal Protection Clause and the 15th Amendment's ban on racial discrimination in voting both contain enforcement clauses. giving Congress explicit power to enact appropriate legislation. The Supreme Court has consistently upheld this authority, most recently in Brnovich v. DNC, which, while upholding Arizona's election rules, reaffirmed Congress's power to set voting rights standards. The studio fell silent as Crockett methodically dismantled Dershowitz's constitutional objections, citing case law, historical precedent, and exact provisions of the bill with striking precision. It was a lesson in constitutional reasoning, delivered not from theory, but from lived experience. Dershowitz attempted several interruptions, yet each time Crockett countered smoothly, demonstrating superior command of both the law and the bill's details. His growing frustration was evident. Finally, in a last effort, he tried what he believed was his strongest point. Congresswoman, with all due respect, I don't think you understand the unintended consequences of this legislation. Section 502 could actually weaken minority voting power in certain local elections. Crockett's smile widened slightly. Professor, I'm afraid that's incorrect. There is no Section 502 in this bill. It contains only 428 sections. The room went completely still. Dershowitz hurriedly shuffled through his papers, realizing too late he had confused this bill with another. A serious mistake for someone claiming expert knowledge. I apologize, he said, voice quieter now. I meant Section 402. Crockett responded evenly. Section 402 deals with ballot drop box. Professor, it has nothing to do with minority vote dilution. Perhaps you're thinking of H.R. 2722 from the last Congress. That was a separate bill entirely. The moment captured what had been unfolding all along. Despite his credentials, Dershowitz had entered the debate without fully reading the legislation, relying instead on talking points. Crockett, who had helped draft portions of the bill, displayed deep understanding and accuracy in every response, sensing the significance of the exchange. Moderator Mitchell turned to Dershowitz, Professor, given the Congresswoman's clarifications. Do you wish to revise your position on any aspects of the bill? His trademark confidence shaken, he replied. I still have constitutional concerns, but I acknowledge that some of my criticisms may have been based on outdated or incorrect information. I'll need to review the text more closely. Crockett nodded with grace. I appreciate that. Professor, I'd be happy to share a full analysis showing how each section aligns with constitutional precedent. Perhaps we can agree on protecting every American's right to vote. Her composed and generous tone underscored the contrast between the two, one clinging to reputation, the other grounded in depth and experience. As the discussion ended, it was evident to everyone watching that they had witnessed a defining moment, a shift in America's legal debate where reputation alone no longer guaranteed authority. Within minutes of the CNN segment airing, clips of Crockett's systematic rebuttal flooded social media, the most viral moment. Her exposing Dershowitz's mention of a non-existent Section 502 hit over 1 million views within an hour. Crockett clapped back, and D-wrong Section 502 trended nationwide. Commentators from all sides reacted. Conservative legal analyst Andrew McCarthy tweeted, "Regardless of your stance on the bill, Crockett just gave a masterclass in preparation." Dershowitz brought generalities. She brought specifics. MSNBC host Rachel Maddow opened her show that night, remarking, "We just witnessed the legal version of David defeating Goliath. Only this time with surgical precision instead of a slingshot." Behind the scenes at CNN, producers who had anticipated a typical policy discussion were rushing to capitalize on what had become the network's most watched segment of the month, overnight. They prepared a special program titled The New Defenders, Rising Voices Reshaping Legal Debate, prominently featuring Crockett in her Manhattan apartment. Alan Dershowitz faced one of the most significant public setbacks of his long career. His phone buzzed endlessly with messages from colleagues, students, and journalists seeking comment. At Harvard Law, internal message boards erupted with debate over the exchange, with several professors noting that Crockett had used the same Socratic method Dershowitz himself once employed to challenge his students. By morning, he released a statement. While I continue to hold constitutional concerns regarding federal election legislation, I recognize Congresswoman Crockett's strong command of the issue. Public discourse benefits from well-prepared advocates on every side, though diplomatic. The statement was clearly seen as an attempt at damage control for Crockett. The aftermath proved transformative. Her office was inundated with interview requests from major networks, and her social media following tripled overnight, recognizing her growing influence. House Democratic leaders invited her to lead a press conference on voting rights legislation the next day. Even more notably, 3 representatives who had been undecided on the bill contacted her office to express their support. The shift in momentum was unmistakable. What had seemed an unlikely legislative effort now appeared achievable across law blogs and academic forums. Analysis flourished. A Yale law professor wrote, Crockett showed that lived experience paired with legal scholarship can produce a more accurate and persuasive constitutional interpretation than abstract theory alone. Georgetown Law soon announced a panel discussion titled Credentials versus Substance: Rethinking Legal Authority in Public Discourse. Civil rights organizations quickly built on the moment. The NAACP and the Lawyers' Committee for Civil Rights Under Law issued statements emphasizing how Crockett's arguments reaffirmed the constitutional foundation for federal voting protections. Activists in Georgia, North Carolina, and Arizona reported surges in volunteer sign-ups for voter education drives, many citing Crockett's passionate defense as their inspiration. Conservative media worked to redirect the narrative. Fox News host Laura Ingraham argued that Crockett's reference to Section 502 didn't address broader constitutional issues. Yet, even on Fox, legal commentators admitted that Dershowitz had been outperformed on substance. He relied on reputation, while she relied on preparation, acknowledged former Judge Andrew Napolitano 3 days after the CNN segment. An unexpected development occurred. Alan Dershowitz requested a private meeting with Congresswoman Crockett in her Capitol Hill office. The seasoned attorney arrived alone without cameras or staff. Congresswoman, he began, his tone notably different from their on-air encounter. I've reviewed the bill thoroughly, while I still have concerns about specific provisions. I must admit your constitutional reasoning was largely sound, he paused, then added, and your point about real-world impact was well taken. Theory without application holds little value. Crockett, gracious in victory, invited Dershowitz to co-author an op-ed discussing their shared principles on voting rights while recognizing their differences in approach. The public deserves to see that constitutional interpretation doesn't have to be partisan, she suggested. After a pause to reflect, he agreed. Their joint op-ed in the Washington Post, titled Finding Constitutional Common Ground on Voting Rights, went viral, not for a takedown, but for modeling a dialogue that crossed generations and ideologies. It ended with a line that captured the moment, when debate centers on substance over status, on evidence over authority. Democracy thrives. For Jasmine Crockett, the exchange with Alan Dershowitz marked a hinge in her public life, not only in her congressional career, but in a broader mission to elevate essential issues beyond partisan reflex. In the week after the CNN appearance, invitations arrived from Harvard, Yale, and Howard Law by the next semester. Enrollments in voting rights courses ticked upward nationwide. The private messages felt even more consequential. Thousands came in from young lawyers, law students, and especially women of color across the legal field who read her performance as a statement of possibility. "You showed us we don't have to minimize our experience to face power," wrote a second-year law student in Michigan. The note was one among many, but it sounded like a bell. In Washington, the political effects continued to unfold. 3 Republican senators reached out to explore compromise on national early voting standards. The distance between the parties didn't vanish, but the center of gravity moved. From abstract constitutional quarrels toward practical design. The space where Crockett had spent years turning text into protections. At a meeting of the Congressional Black Caucus, Congressman James Clyburn distilled what many were saying more quietly. "You didn't just win a debate," he told her. "You changed how this issue will be discussed from now on. That's how lasting change begins." 6 weeks later, a revised Voting Rights Protection Act passed the House with bipartisan support. The Senate path remained uncertain, but the dynamic had shifted. The bill carried a momentum few had predicted before the viral moment. Analysts credited Crockett with reframing public understanding, bridging the constitutional with the concrete, the theory with the lived. Across the media ecosystem, the Crockett-Dershowitz exchange became a case study in how authority is earned in public life. Credentials still mattered, but they no longer overshadowed preparation and experience. A new generation insisted on recognition not for affiliations, but for rigor, for viewers. The confrontation was a rare instance of genuine intellectual engagement on live television. It cut across party lines and reached for something deeper, the ongoing national question of who truly has a voice in a democracy. At the ballot box and in the conversation that shapes it. Later, reflecting with her team, Crockett was careful to define the win. "This was never about embarrassing Professor Dershowitz," she said. "It was about ensuring every voter's right to participate in democracy, protected both by constitutional interpretation and real-world practice. When legal theory meets lived experience, that's where justice begins." In the semesters that followed, communications, law, and political science programs added the exchange to syllabi, a clean example of how preparation, expertise, and moral conviction can challenge established authority. The lesson landed beyond one news cycle. In a healthy democracy, ideas stand or fall on their merits, not on the titles of those presenting them. And as the debate over voting rights continued across the country, one fact hardened into place. A new voice had taken the national stage, and it wasn't leaving. Share your thoughts below. I genuinely want to hear from you. If this resonated, like, share, subscribe, and hit the notification bell to catch more stories like this. Check out the featured video on your screen. It's a story I'm especially proud of. Thank you for your support, and see you next time. We are Jasmine Crockett File.